there you can.
Understood. So we speak about, I just want to go back to the organizational perspective. So we've got children who are the data subjects, however, their guardians or their parents give consent. From a school perspective, what are we teaching children about being data subjects when we speak about data subject participation? Because there is a big component of training and awareness there. What should a child know about being a data subject?
I think education regarding data protection, similar to what they do in Europe, is something that you need to be taught in your basic education. I think, and I speak for myself, not as the regulator, but I think there has been a very slow importing and appreciation for the constitutional rights by our basic education department. You know, in European countries, the Constitution of Europe and the Constitution of those countries is something that gets entrenched in the children on a primary school level. As much as you should know the national anthem, you must know the rights and the Bill of Rights. So, you know, kids need to appreciate that there is a thing called data protection. In countries like Germany, children know that there's a thing called Datenschutz. Children know that you don't just give out your personal information, that there is a law that specifically regulates that. So I think from a policy perspective, government must really go out of its way to try and look at its curriculum to see where the basic rights in the Constitution, in particular here, the right to privacy, and as it is formulated in POPIA, how they can simplify that so that children understand it. I mean, it's one thing that mommy and daddy know what POPIA is about, but if the children don't know what it's about, then we might as well not be having this exercise. So it's very important that schools, even if it's not within their curriculum, that they really insist to bring in measures to simplify the understanding of privacy and how it impacts on them in terms of POPIA.
Mr. Snail, I'd like to, let's say, paint a picture. Let me put a scenario to you. So we have a school, and the school has maybe 5 extracurricular activities, and one of them is hockey, for instance. And then there's a external hockey academy. It has got nothing to do with the school. And then the hockey academy approaches the school and says, "Hi, school, we've got this amazing hockey academy, and we can assist your students to become better at the sport and maybe get some South African representation or, you know, school colors." So then school agrees to then get these documents to parents, and these documents ask for personal information. And then the parents fill that information in, collect this data, and then give it to the school. Give it back to the academy. In this scenario, what is the responsibility of the school in relation to them collecting this data for the purposes of the students going to this academy, this external academy? What safeguards, what measures, what does the school ask this third-party institution? What do they have to do? What needs to be in place?
You know, like I said, once again, the regulator is very shy from giving advice, and that is really a policy decision of the regulator. But I think you need to go and look at POPIA itself. POPIA is very clear. If the school has collected personal information of children to enroll the kids for them to be at the school, they have no business in sharing any personal information with any third party, be it a third party service provider, be it a sports academy that may want to render services to the school or some of the children at the school. Those particular organizations would have to have a separate consent form, a separate form where they are collecting this personal information. There is no prohibition on approaching the parents. Similar to the direct marketing provision in Section 69, even with direct marketing, you still have a right to once approach the data subject and get its consent. So the key word here is consent. If the academy is of the view that it wants to get children from a particular school, the first step would be to go to the school, market whatever services that they want to market, and then give the children a form which they can give back to their parents to complete. And then in that process, they can lawfully obtain the necessary consent that is sought by law.
That's quite interesting. It sounds like there will be a massive change, because I've got a younger brother, and I've seen that schools don't necessarily follow that. Might not necessarily be his school, but he's got peers, that do go to other schools. I think one of the questions that if I was a school, I would ask, what do the penalties look the same for non-compliance? So for instance, if the school happens to be reported by a parent to say, XYZ information was taken, and I don't understand why this particular marketer is talking to me, and I know that this is the only place that my child's information could have been breached or leaked from. What would that process look like for school if the information regulator had to go find this information out, or try and audit at least? Is there a method that the information regulator uses? Is there a way of a parent contacting the information regulator? What is the simplest, I guess, human explanation outside of being a professional in the field to a parent? What's the pathway? Secondly, what would that look like for the school?
There is no specific formula or a magic wand to decide, given against a responsible party that either breaches or fails to protect the personal information of children. Every single case is dealt, and we look at the gravity of the abuse and in the manner in which the personal abuse of the information has occurred, and the extent to which the personal information has been shared with unauthorized persons. As I said, it would be anything from 1 rand to 20 million rands, and every case is looked at its own facts. But I can tell you, any breach of children's special personal information, because of the express prohibition on the processing of personal information of children, that will most likely have more punitive effects.
Is looking at some of what clients would say, when you tell them, look, we'd like to assist you with XYZ to be compliant, they tell you, oh, no, that particular section of our organization, or that what we do is not digitized. We don't keep information in digital format, therefore POPIA does not apply to us. And when I look at that example, if I extrapolate that and apply it to schools that are in rural villages or places that might not have, the resources from a technical and electricity perspective that keep their information for their students, their employees, their applicants in a physical format, so in files, in cabinets, would POPIA apply to them as well?
Yeah, there's a general fallacy that POPIA only applies to the digital world. And I think that is because primarily now the processing of personal information is done digitally. But with that having been said, data protection has its origin from some of the most nastiest experiences that we've had as humans. You will recall during the World War, the use of personal information of Jewish people that was used to strategically discriminate against them, as well as strategically exterminate them. That was done at the time in hard copy documents and papers. We also then had the apartheid regime, where either persons' letters would be intercepted, their personal information would be shared with various arms of the state regime in order to pursue people and also to further the means of oppression against a particular class of persons. So data protection is really not just akin to the cyber world, but it is also akin to the paper-based world. Your bricks and mortar world still has application to POPIA, and as much as I have a duty to safeguard information that is kept electronically, if I am in a rural community and we still have a file system, then the POPIA will say, from a technical point of view, that you must lock that particular cabinet, you must have measures to make sure that that room is locked, and from an organizational point of view, you must see to it that only certain persons have got access to that key. So once again, POPIA does not only apply to the digital world, but it also applies to our bricks and mortar world. I hope that given you some clarity.
No, it definitely does. And, you know, just piggybacking on that example, just that really in-depth explanation. When it comes to now the amount of time, so, you know, the legislation does say that it needs to be kept for a reasonable amount of time. So let's say 5 years, you know, looking at other legislations that speak about keeping information for a specific amount of time. When it comes to now the part where you need to get rid of that information because it's no longer relevant and you've actually got no business interacting with that information, what does that look like? I mean, how does one get rid of that kind of evidence? Would there be something that the information regulator, maybe 5 examples of getting rid of personal information in a manner that is suitable? With the best way, I mean, just at the top of my head, be returning that information to the owner in the form that it was given, if we speak about the bricks and mortar example?
I think in the bricks and mortar world, the return of personal information would be an option, although I don't foresee an organization going through all its files and records and extracting the documents and giving them back to every single person that has given them information. I think there, instead of returning it, I think destruction would be the more wiser way to go, either by way of a shredder or even extreme by literally destroying or burning the documents to ensure that they are destroyed. So even in the bricks and mortar world, there is a duty to either return the information or to destroy it so that it cannot be used for other purposes that it is not meant for.
So we speak about destruction and destroying. So this is to ensure that there isn't a breach or just access by people that should not be in contact with this personal information. And that just makes me think of some of the discussions that we've had with clients. And then the penalties come up. And we speak of, you know, going to imprisonment of up to 10 years, according to POPI or POPIA. Is this a real thing? I think people think that, you know, when we speak about it, we're joking or we're trying to scare them into something. But maybe if you can deep dive into that penalty of imprisonment of up to 10 years, is this a real thing? You know, clients think these are tactics by POPIA specialists, you know, trying to get them to be compliant, but maybe tell us a bit more about that.
The provisions regarding to the criminal aspect of POPIA, they're quite well defined, and you will find them in the sections post sections 100. I think it's in 103, 104, and 105, where they give specific instances of specific personal information, such as personal account numbers, where those have been used unlawfully. There could be criminal sanction. Or where an information officer of a particular organization has conducted himself so badly with personal information that the information regulator would recommend criminal prosecution. The regulator itself will focus more on the fining, the administrative fines, and then where the regulator feels that really there have been very bad transgressions or transgressions that are within the framework of the criminal law. Like I said, there's very few sections that deal with that in the POPIA. Then obviously those will have to be referred to the relevant law enforcement agencies for criminal prosecution. But it is not, we're not scaring anybody. People will go to jail if they do conduct themselves in a particular way that is deemed to be criminal in terms of the act, and the fines will also be there in the event where there has been breaches to the protection of the personal information of individuals.
I think just as a follow-up question, thank you for that, Mr. Snail. As a follow-up question, pertaining to this up to 10 years imprisonment, and this would look at, information being leaked pertaining to account numbers. For the purposes of schools, would this also include the personal numbers belonging to educators in public school environments? So the personal numbers that the Department of Education would use to pay in the particular teachers' accounts, would that still fall under accounts?
Look, account numbers are account numbers. Whether they belong to teachers, whether they belong to mine workers, whether they belong to cleaners, whether they belong to execs, whether they belong to retail workers, account numbers are account numbers. So if you look at the section, and if you follow the criminal law, we use a deductive reasoning. We have to dissect the provision relating to criminality. So if it says anyone who intentionally and unlawfully shares or processes an account number, then that is what the law says. It doesn't matter what type of account number it is. It could be the account number of a teacher, could be the account number of even a juristic person. As you would know, that the POPIA doesn't just apply to living persons, but also to juristic persons. So once again, this hasn't been tested yet, but I'm sure people would not want to be an example or a test case pertaining to that. And for that, we need practitioners such as yourself to really educate the public and their clients about the possible dangers of this. I mean, I can't tell you how it will turn out. We haven't necessarily dished out any fines yet, but we will be looking at foreign jurisdiction and seeing how they have dealt with these cases from the 1st of July, once we are empowered to give fines as well.
Now, Mr. Snail, maybe let me ask you this: from a reputational risk perspective, does this this grace period that's been given until the 1st of June 2021, does that really, should that make people scared? So for instance, the Information Regulator dealt with the Experian situation not too long ago. And I mean, in the media right now, there isn't a lot of talk. Do you think that after the 1st of June, there would be, sort of more talk about it? This becomes more of an issue in South Africa, where people are taking it seriously or taking data breaches seriously. Do you think that this is actually what's needed? Are we going in the right direction in terms of national accountability?
Look, the duty to self-report in terms of Section 22, as I said, is a duty. It is not a like to have, it is not a want to have, it is a duty. So the duty to self-report, that is applicable. I mean, the regulator has a data breach register where we record these breaches, and in certain instances, we also advise responsible parties on how to notify the data subject. You mentioned Experian. There's been a lot said in the public. The regulator has made joint statements with Experian as well, and we've noticed that, unfortunately, there seem to be many stories as to what really happened. And for that reason, the regulator has now gotten an independent forensic investigator to investigate the whole occurrence, the whole breach. So I'm not at liberty to discuss with you the intricate details of that, because I would say it's in a way sub judice. It is still subject to investigation. But data breaches are a reality. A lot of law firms, a lot of small law firms, big law firms, they are really assisting their clients in self-reporting. I see our state president is flying over my office in his helicopter. So it is really a risk to an organization. People always say, from a reputational perspective, you should not self-report. That is absolute, in contravention with what 22 says. 22 says, please self-report in the event of a data breach, so that the regulator can then tell you what to do about this breach. So no, there has been numerous self-reporting. you will notice in our annual report, where we then give the numbers of these breaches, you will see that there have been several breaches. Some of them have been publicized through the media, but there have been other breaches that have taken place, and the parties have done the right thing and they have self-reported.
So, Mr. Snail, would you then say that in this particular example, or rather, let me ask you this, are you at liberty to tell us how many reports has the Information Regulator received, at least maybe in the year of 2020 so far to date in 2019, more or less? And have any of those been schools?
I must refer you to the annual report of the regulator. It's a public document, and that is where you will find that. I don't think you will find any information pertaining to schools being reflected there, or children, as that would be expressly in contravention with this prohibition that I've just told you about. But I would encourage you, if you're looking for stats of the regulator, the annual report of the regulator is available on our websites, and that is where you will be able to see how many breaches have been reported in the past year. Our annual report for this year is also due quite soon, and that you will also then find on the website.
Mr. Snail, thank you so much for participating in our informative talk and the stakeholder engagement and just advocacy. Our aim as Digital Legal is to create a really robust discussion when it comes to data processing and data protection. And I thank you. And I think the only way that we will create a country and just a world that is accountable when it comes to data protection and data processing, especially pertaining to our most vulnerable in our society, who are our children, is by doing exactly this. And I think on our end as Digital Legal and myself as the founding partner, I am excited you've given us more information, or just you've given us hope. And you've shown us that the Information Regulator does take this seriously and does take information seriously. And for that, we thank you. And we look forward to engaging with you on other topics, because we do know that it's, where data intersects with just everyday business, it's quite vast, and there's no way of limiting our conversations. So we thank you so much, and we thank your office so much for giving us this time, and we look forward to engaging with you further.
Thank you very much for inviting the Office of the Regulator. It's always a pleasure to participate in these form of stakeholder engagements. And we look forward to hearing further from your organization. And if through this effort, there are other engagements that can culminate from this, please feel free to approach the Office of the Regulator, as awareness and education is really our top priority.